He sat in a prison cell for over 20 years. Convicted of murder on the testimony of a single witness. But here's what you need to know about that witness. He later said the whole thing was a script. That the detectives told him what to say. That he was drunk, scared, and just trying to get out of a police station. That the man rotting in prison for a killing he described, Chancellor Aaron, was not the person he saw that night. And here's the part that should make you stop whatever you're doing right now. When the states sent their own investigators to challenge that recantation, to break it down, to prove it was a lie, those investigators came back with the same story. The witness hadn't changed his account. Not even a little. So why did it take 20 years to get a new trial? Videos like this one don't happen without serious work. I'm talking appellate court opinions going back to 2005, post-conviction hearing transcripts, witness affidavits, investigative reports, hours and hours of reading just to give you the complete picture that nobody else is putting together. If you believe that cases like Chancellor Aaron's deserve to be heard, that real people buried inside the justice system deserve to have their stories told properly, hit subscribe and turn on notifications right now. It costs you nothing. It means everything to this channel. And it keeps this kind of work alive. Now let's get into it. This is the case of Chancellor Aaron, convicted of first-degree murder in Cook County, Illinois in 2005, and sentenced to 45 years in the Illinois Department of Corrections. 45 years. For a crime the key witness later said he didn't commit. Give me a little of your time, I'm going to walk you through everything, the night of the shooting in May 2002, the witnesses whose stories kept shifting, the legal system that failed Chancellor Aaron at nearly every turn, and the single document that a court eventually could not ignore. I'm going to show you how a man gets convicted when there is no physical evidence. No confession. No arrest at the scene. Just the testimony of a witness who was high, scared, and by his own later admission, essentially reading from a script that the police had handed him. I'm going to show you how that conviction survived appeal after appeal. How post-conviction petitions were filed and denied. How a new piece of evidence emerged, only to be misread by the very court that was supposed to evaluate it. And I'm going to show you what finally broke it open. Because here's the thing about this case. The evidence of Chancellor Aaron's innocence didn't come from his defense team alone. It came from the state's own investigators. And even then, it almost wasn't enough. Chicago. May 7, 2002. It's early evening, somewhere between 7:30 p.m. and 9 p.m. depending on which witness you ask, a detail that will matter more than you might think. The sun is going down over the south side. People are outside. Kids are around. It's the kind of summer evening that feels ordinary right up until it isn't. On the corner of 71st Street and Paxton, a group of young men are standing around. Among them is Aaron Crawford, the man who will not survive tonight. With him is Daniel Wesley, a man who has known the neighborhood, known these streets, known these people for years. Across the street, according to what Wesley will later tell police, are two men from a rival gang. What happens next takes 5 seconds. Wesley will say this himself under oath, 5 seconds from the moment he saw the two men to the moment the shooting was over. During those 5 seconds, Wesley was running. Now think about that. 5 seconds. Running. Having smoked marijuana earlier in the day and drunk gin before the shooting. Aaron Crawford ends up on the ground with a single gunshot wound to the chest. His friends put him in a car and rush him to the hospital. He doesn't make it. Daniel Wesley ends up at a restaurant a few feet from the shooting with blood on his shirt, not his own blood, when police officers walk in and notice him. And Chancellor Aaron, a young man from the same neighborhood, someone Wesley had known for more than 7 years, ends up at the center of a murder investigation he will spend the next 2 decades fighting to escape. Now here's what you need to understand about Chancellor Aaron before this story goes any further. He was not arrested at the scene. There was no physical evidence connecting him to the shooting. No gun recovered. No fingerprints. No DNA. When the police first brought in a witness and showed her a lineup in July 2002, the assistant state's attorney who came to interview her refused to approve charges. When they tried again in December 2002 with a second lineup, the same thing happened. The ESA declined to charge. The only reason Chancellor Aaron eventually ended up in prison is because of Daniel Wesley. And Daniel Wesley, it turns out, had a story that changed, and changed, and changed again. Here is where the story stops making sense. On the night of the shooting, Detective Fassel interviewed Daniel Wesley at the police station. Wesley had blood on his shirt. He'd been at the scene. He knew the victim. And according to Detective Fassel's own testimony, on the night of the shooting, Wesley stated that he did not see whether Chancellor Aaron was armed at the time of the shooting. Read that again. The night of the murder. The detective who took his statement. Wesley said he could not confirm Aaron had a gun. That should have been the end of Wesley as a credible witness against Chancellor Aaron. But it wasn't. Because almost a year later, in April 2003, Wesley was arrested again, this time for possession of a firearm. He was brought in, he was not free to go, and he signed a statement. A statement that was, by Wesley's own later description, written out for him. 6 days after signing that statement, 6 days, his gun case was dismissed, and he was released. Then, in May 2003, he testified before the grand jury, implicating Chancellor Aaron in the Crawford murder. And when the case finally went to trial in September 2005, Wesley was brought back from Minnesota, where he'd been living on the street before enrolling in a job training program, under a material witness order, held in custody, and told to give the same statement he'd given the prosecutor. At trial, Wesley himself described what the ASA had told him to do on the witness stand. He said she told him to give the statement he had already given, and not to use Aaron's nickname. He was literally describing the script. But the jury convicted Chancellor Aaron anyway. Here's something the jury at Chancellor Aaron's trial needed to know but didn't fully appreciate. By the time Daniel Wesley took that witness stand in September 2005, he had given statements about the Crawford shooting at least 7 times. And those statements did not tell the same story. On the night of the shooting, couldn't confirm Aaron had a gun. In April 2003, arrested, signs a written statement implicating Aaron. Case dismissed 6 days later. May 2003, grand jury testimony implicating Aaron. December 2004, Wesley meets with Chancellor Aaron's defense attorney, Joseph Breen, and signs a completely different statement. This one says he cannot identify the shooters. That he identified Kirk, or Haw and Chancellor Aaron because police detectives told him to. That neither face he saw belonged to Chancellor Aaron. That his previous statements and grand jury testimony were made because of threats from detectives. September 2005, at trial, Wesley takes the stand and says the statement he gave to Breen was not true. He denies anyone threatened him. That's 5 versions just through the trial date. And here's the part the jury never got to see in full. That December 2004 statement, the one where Wesley said he was coerced and that Aaron wasn't the shooter, the trial court only allowed a small portion of it to be presented as impeachment. The jury never saw the full statement. Never read the words, "He did not do this, and it wouldn't be fair for him to go to jail for something he did not do." The jury convicted on September 8, 2005. Chancellor Aaron was sentenced to 45 years. And Daniel Wesley went back to Minnesota. For years after the conviction, Chancellor Aaron's legal team fought through the post-conviction system, filing petitions, watching them get dismissed, filing appeals, watching those get denied. Then something happened that changed everything. In 2007, Wesley was brought back to Chicago, this time to testify at the separate trial of Chancellor Aaron's co-defendant, Kirk Haw. Before that trial, Wesley did something remarkable. He told the 2 assistant state's attorneys handling Horshaw's case that his testimony against Chancellor Aaron in 2005 had not been true. He was threatened with prosecution for perjury. He testified anyway. At Horshaw's trial, Wesley said he had been drunk and didn't know what he was saying when he spoke to detectives. He said his identification of Chancellor Aaron was, in his own words, script. He said when you're being shot at, you're not stopping to identify faces. You're running. Chancellor Aaron's legal team got hold of that testimony transcript. In January 2013, They filed a motion for leave to file a successive post-conviction petition, arguing that Wesley's recantation at the Oha trial was newly discovered evidence of actual innocence. The trial court denied the motion. But the appellate court reversed that denial in 2015, finding that Wesley's recantation was of such a conclusive character that it would probably change the outcome at a new trial. Chancellor Aaron finally had a foothold. But the system wasn't done making him fight for it. Here's the moment in this story that genuinely floors me. After the appellate court's 2015 ruling, the case was sent back down for what's called a third-stage evidentiary hearing, a full hearing on Aaron's actual innocence claim. The state was given the opportunity to investigate the witnesses who had submitted affidavits supporting Aaron's innocence. In April 2018, the state completed its investigation. They had sent 2 of their own investigators, from the Cook County State's Attorney's Office Investigations Bureau to a Minnesota correctional facility where Wesley was then incarcerated. Their job was to probe Wesley's recantation. To test it. To find the holes in it. They sat down with Wesley in that jail cell. They reminded him that he had said he couldn't see the faces of the shooters, and asked him pointedly. If he couldn't see their faces, how could he be sure it wasn't Chancellor Aaron? Wesley had an answer. He said he knew Chancellor Aaron's build. Had known him for years. And neither shooter's build matched Chancellor's. When the investigators were finished, they filed their report. And that report confirmed that Wesley maintained the same account he had given to defense counsel. That Chancellor Aaron was not one of the men who shot Aaron Crawford. The state's own investigators had gone looking for a reason to dismiss Wesley's recantation, and they had come back empty. That report was dated July 31, 2018. It was signed by the investigator and his supervisor. It was admitted into evidence at the third-stage hearing without objection. And then, somehow, the trial court barely engaged with it. By the time the third-stage evidentiary hearing finally took place in October 2023, delayed for years partly by the COVID-19 pandemic, the evidence supporting Chancellor Aaron's innocence had grown considerably. There was Wesley's recantation testimony from 2010 at the Oha trial. There was Wesley's 2017 affidavit, signed and notarized, stating that his original testimony against Aaron was coerced and untrue. There was the state's own 2018 investigative report confirming Wesley's account. There were 2 additional eyewitness affidavits, from Adrienne Kennard, who said she had known Chancellor Aaron since first grade and that he was standing with her on the opposite side of the street when the shooting happened, and from Barbara Lindsay, who said she witnessed the shooting and the shooter was light-skinned, which did not match Aaron's description. On January 4, 2024, the trial court denied the petition. The court said the newly discovered evidence was not of a conclusive enough character to change the result on retrial. The court said the jury had already heard about Wesley's contradictions. But here's the critical error, the one the appellate court would later find unforgivable. In its written order, the trial court referred repeatedly to Wesley's 2018 affidavit. But there was number 2018 affidavit. There was a 2017 affidavit from the defense, and a 2018 investigative report from the state. The court had conflated the 2 documents, quoting language from the 2017 defense affidavit while attributing it to the 2018 state report. By merging those 2 documents into one, the trial court had effectively erased one of them from its analysis entirely. It never considered what it meant that the state's own investigators had confirmed Wesley's recantation. It never grappled with that specific, devastating fact. The defense filed their notice of appeal on January 11, 2024. The Illinois Appellate Court's opinion in People v. Aaron, filed April 10, 2026, is the kind of document that makes you understand why appellate courts exist. The court went through the trial court's order line by line. It identified the conflation of the 2017 affidavit and the 2018 investigative report. It explained exactly why that error mattered. Because those were not the same document. They were not the same source. One was obtained by the defense. One was obtained by the state. And the fact that both said the same thing, that Chancellor Aaron was not the shooter, was precisely the point. The appellate court noted that the original trial evidence was far from overwhelming. No confession. No physical evidence. No arrest at the scene. The state had twice refused to charge based on eyewitness Karen Luckett's identification alone, a fact that spoke volumes about how much the prosecution itself had always depended on Wesley. The court observed that Luckett's trial testimony had its own problems. Her statements about whether she saw Aaron with a gun shifted. Her account of the timing of the shooting shifted. She admitted she had never seen Chancellor Aaron before that night, and that he looked different to her at trial than he had on the night of the shooting. There was also a detail lurking in the record that the court flagged quietly but pointedly. Chancellor Aaron may have been wearing an electronic monitoring device on his ankle at the time of Luckett's lineup identification, which would raise its own questions about whether he could have been the one running from a shooting. The appellate court concluded that the trial court had failed to consider the totality of the evidence. Wesley's recantation was not ordinary recantation evidence, which courts routinely treat with skepticism. Wesley had given consistent statements to defense counsel, to the Oahu trial jury, and to state investigators across 13 years. Each time he was asked, the answer was the same. The court reversed the conviction. Chancellor Aaron was granted a new trial. Okay, I have to stop here because I want to know what you're thinking right now. Because at this point in this story, you have a man who has spent over 20 years in prison. You have a key witness who said to the defense, to a courtroom, and to the prosecution's own investigators that his original testimony was scripted and untrue. You have a trial court that reviewed all of that evidence, and still said it wasn't enough. So here is my question for you. At what point does newly discovered evidence become enough? How many times does a witness have to recant, to how many different people, under how many different circumstances, before the courts say, this conviction cannot stand? Drop your answer in the comments. I read every single one. And I genuinely want to hear from you on this one because the answer isn't as simple as it sounds. Let's talk about what the appellate court actually found because this is the moment everything comes into focus. The court had previously ruled, back in 2015, that Wesley's recantation testimony alone was of such a conclusive character that it would probably change the result on retrial. That was based on one piece of evidence, Wesley's 2010 testimony at the Oahu trial. By 2024, there wasn't one piece of evidence. There were multiple. Wesley's 2010 recantation testimony. Wesley's 2017 affidavit. The state's own 2018 investigative report. Adrian Kennard's two affidavits placing Chancellor Aaron on the opposite side of the street at the time of the shooting. Barbara Lindsay's affidavit describing a shooter who didn't match Aaron's description. And the trial court had responded to all of that with essentially the same dismissal it had used back in 2013. The jury already knew Wesley gave contradictory statements. The appellate court called this out directly. It said the weight of those contradictory statements then and now is not the same. In 2005, the jury knew Wesley had given some conflicting accounts. What the jury did not know, what no jury had yet been asked to consider, was that Wesley had maintained his recantation across 13 years, to defense investigators, to a separate trial, and to the state's own agents who came looking to disprove him. The court's final conclusion was direct. Our confidence in the prior verdict is undermined. A retrial is warranted. On April 10, 2026, nearly 24 years after Aaron Crawford was shot dead on a Chicago street corner, Chancellor Aaron was granted a new trial. He has never stopped saying he didn't do it. What happens next? Whether the state pursues a new prosecution, whether that case can even be built without Wesley as a cooperative witness, whether Chancellor Aaron will one day walk out of prison, remains to be seen. What we know is this. A man spent over 2 decades incarcerated on the testimony of a witness who gave at least 7 different accounts of the same event, and who ultimately told the same story to everyone who asked him after the conviction. That story was, Chancellor Aaron did not do this. The criminal justice system has rules designed to protect convictions from being endlessly relitigated. Those rules serve a purpose. But they also create situations like this one, where a man who may be innocent has to fight the same battle over and over again, at every level of the court system, for decades, while the evidence supporting his innocence quietly accumulates in case files that nobody is required to read together. The appellate court in Illinois finally read them together. It took 21 years. If you find yourself genuinely angry at any point in this story, then you already understand why this channel exists. These are not abstract legal arguments. These are real people. Real years. Real cells. Real families waiting. If you want to see more cases like this one, cases where the cracks in the justice system are real and the stakes are someone's entire life, subscribe right now. Every video on this channel is built from actual court documents, actual transcripts, actual testimony. Not speculation. No filler. Just the truth of what happened and what the courts said about it. Like this video if it moved you. Share it with someone who thinks the system always gets it right. And the next one you will watch will be as shocking as this because law and justice is never black and white. You will not want to miss it. I'll see you there.